Good morning, ladies and gentlemen. It's a particular pleasure to be here in Naples with you. I'm going to talk, since this is a conference on shipping and the law, I thought I would start with the law. And in Europe, that is, of course, the treaty on the functioning of Europe. And if we speak about ports, you'll find, first of all, a remarkable conclusion that the word port doesn't appear in that treaty. But that doesn't mean it doesn't apply. And there are two important dimensions that I would like to share some views on with you this morning. And that is, first of all, the infrastructure dimension, which are the trans-European networks to which Alphonse referred. And secondly, the application of competition and internal market rules. I will try to elaborate both dimensions briefly and also highlight especially what's new, because indeed, as Alphonse was saying, there is something in the pipeline. Actually, there are several things in the pipeline that are quite relevant for the ports. Starting with infrastructure, with the trans-European networks, they were part, or they became part of the treaty in the early 90s. The objective of the 10T, as we call them, is clear. It is to connect Europe. It is to connect the infrastructure master plans of member states. It's to do away with bottlenecks. It's to improve the cohesion of Europe. That's the dream, if you like. That's the vision behind 10T. I think we can also say that how this was implemented in the past 15 years or 20 years or so, it was not really close to that vision. I think what we've seen up to now was an amalgamation of national shopping lists, national priorities, which were put together in a list of about 30 priority projects. Some of them with a clear added value, but not all of them. I think that is the problem that we have had. For us as a port industry, the additional problem is that we were not really part of those 10T. We were part on paper, but not in reality. I must also add that that is our own fault, because we had difficulties as an industry, certainly in those days, to come up with priorities, identifying which ports, which connections are of European priority and which are not. It's a delicate question, and in the 90s we didn't manage to come to a conclusion to that, which as a result means that we were not present, only on paper with a list of about 300 ports, which is not really a priority network. I think that was the general problem with the whole 10T discussion, and a couple of years ago the Commission announced that they would make a revision of the policy. And with a different approach, with a clear approach on the European added value, the European or pan-European added value. I'm happy to say that meanwhile we managed in our industry and in the organization that I represent to do away with the old philosophy that, we shouldn't be talking about priorities. We managed to accept the principle, which is the overall principle of the new 10T policy, that you have a core network of infrastructure in Europe and you have an underlying, a broader comprehensive network. Both are important, but in terms of European support, obviously the core network has priority. We accepted that philosophy also in our sector, in our port organization, which wasn't easy. I can tell you it was quite a difficult discussion to get there. The results are there. They were on the table, or they came on the table last Wednesday, a new package of proposals, new 10T guidelines and a financial framework. The essence is what I mentioned, is a dual layer system with a comprehensive overall dense network and then a core network of priority infrastructure for Europe. That core network will be essentially implemented through a number of multimodal corridors. There's a list at the moment, a proposed list of 10 corridors. Now, how are the ports present in the system? Quite prominently. It's a difference between the new package and the old package. We're of course still part of the comprehensive network. There's still a list of about 300 to 400 ports included. And then there are, as Alphonse said, 83 ports or port clusters that were included in the core network. And also most of the 10 multimodal corridors start and end in seaports. So you could say that we are present in three ways in this new package. I think we can conclude from that contrary to the previous exercise, ports are on the maps. But what does it mean in practice? And that's the real key question. What does it mean in terms of money? Because I think that's what everybody is thinking of. It's nice to be on the map, but what does it mean in terms of getting European support? The financial framework, which is together with the guidelines foresees for the period 2014 to 2020 31.7 billion euro, of which 10 billion euro comes from the cohesion fund. That will be spent on the achievement of the core network. You could say this is perhaps not so much because the overall assessment in terms of financial needs for the European infrastructure network is about 500 billion. So the European contribution would be something about 31 or 32 billion. How would it work? It's essentially a process still running through member states, but there are possibilities to get grants up to 20%. And for rail and barge bottlenecks and cross-border problems, you can even get up financing up to 40 to 50%. For ports or infrastructure located in cohesion fund countries, this can even go up to 85%. It's quite a complex proposal, and given the limited time, I'm not going to go in a lot of detail, but our assessment is that a lot of this 31.7 billion euro will be spent on the multimodal corridors. Next to that, of course, there are other funding possibilities, the existing funding possibilities like Regional Development Fund, Cohesion Fund, and also loans from the European Investment Bank, which are possible. That's on the money side. Second, planning. What the Commission wants to achieve is that this priority network is realized in a fairly short notice with not too much delay and with a good cooperation between member states, especially for cross-border projects. I think we all know from the different angles in Europe where we come from, problems that exist in getting major cross-border infrastructure projects realized in time. In my part of the world, which is Belgium, Antwerp, we know some of the issues with our Dutch neighbors, which have taken a lot of time, but I think we have others as well in other parts of Europe. And this is something that the Commission has recognized and really proposes also measures to get this cooperation between member states much better so that assessment in terms of economic assessment, but also, for instance, environmental assessments are not unduly causing delays to major projects. That's the second implication. The final or the third implication is that being on the 10T is not only a way to get projects done, it's also kind of quality label, which involves obligations. And if we look at ports, those ports that are in the core network, for instance, will have to make sure that they are properly connected, that they have the proper hinterland connections, at least rail, and if they have waterways, also barge, by 2030. But there is more. Ports in the core and the comprehensive network must also fulfill a number of conditions in terms of free market access and transparency. And that brings me with the second dimension that I wanted to share with you this morning, which is the competition and market access issues. Alphonse referred to it. I think ports are at the moment in Europe one of the few, if not the only, part of the transport industry that is not regulated at European level. There have been 2 attempts, and I learned this morning that one of these attempts was even created in a room here in Naples, if I got my friend Leo Delvede correctly. But both of these attempts failed, and we know why. I don't think we need to go into the details. That leaves a port sector which is generally ruled directly by the treaty rules on competition market access. There's not a lot of case law from the European Court of Justice, at least no recent case law. All the major cases concerning ports seem to be more from the 90s. And we have a soft law communication from 2007, which just sets out a few basic principles. That's what we have at the moment. The question is this enough? Is this sufficient? Of course, the port sector is a competitive industry throughout in Europe, but at the same time, in all honesty, I think we also have to admit that there are still some restrictions here and there which could be solved, should be solved, if we want to improve the competitiveness of the sector. The Commission also sees that, and they've announced early September that they would like to make a new ports package by the beginning of 2013, so within a good year from now. This is of course a delicate exercise because we still have to deal with the legacy of the past, and in some parts of the industry the word port package or port services directive is enough to bring people on the streets, to bring the dockers on the streets, and to create a lot of unrest. And that is of course something we as industry, and I think also the Commission, wants to avoid. Content-wise, I don't think there's a lot of arguments. I think the issues are clear, and I tried to summarize them, that's my personal view, in 4 questions that really Europe could answer and could help us with. And the first question is the public financing question, the state aid question, which we have been asking for years, but where at the moment we still haven't got the clarity that we need in terms of where can a government, be that a local government or a central government, finance or co-finance infrastructure? When does it become a state aid? When is it something that is in the general interest? Linked to that is, of course, I know a very peculiar question or sensitive question here in Italy, the question of financial autonomy, which more or less goes hand in hand with this discussion. The second question is concessions, lease agreements in ports. There is a horizontal directive in the making from DG Market, but we're still struggling a little bit with the definition. I know in the south of Europe there is no argument. The question of concession is quite well also in the national legal frameworks, but in the north of Europe, a lot of countries, the term is unknown, and terminal operators simply have lease agreements from the port authority. Should they be governed by the same rules or not? And how can we come to some further legal certainty and harmonization in this field? I think that's a very important question too. It was the essence of the first Port Services Directive, but where we still are struggling with a number of open questions. The most important question being, how can we to some extent guarantee continuity of investment in the ports, and how can we make sure that prolongations of contracts are not kind of foreclosure of the market. So how can we balance both things? The third question is on the technical nautical services. Pilotage, towage, mooring. In many member states, and I know Alphonse doesn't like this term, but in many member states they are qualified as services of general economic interest. And again, here is the question, how can we manage or balance the need for competition, be it competition in the market or competition for the market, with public service and safety concerns? I think that's the essential question number 3 that could be answered. And then fourth, last but not least, the most tricky one, dock labor. How can we operate labor pools and at the same time ensure principles of free market access, freedom to provide services? Labor pools have been tested by the Court of Justice on competition grounds, but that can only be in the case that a labor pool is seen as an undertaking, which in most cases it isn't, and therefore the only kind of test that you need to do is to make sure how does it fit with principles of freedom to provide services. I think that's again an open question where some clarity from Europe could help. So that's content-wise, I think. I don't think there's much room for discussion on those. These are essential questions where Europe could have an added value. The real question is what form will they take, or will the answers take? Are we going again for an all-over approach, one directive, where everything will be put in one box, with the big risk that those who don't like one part of it will try to kill the whole thing, because that's what happened with the previous attempt? Or will it be a more fragmented approach, a better mixture of non-legislative and legislative instruments? It's a bit early to say that. I think we have to get the content of the story right first, and I think we could then discuss the pros and cons of the instruments. So that's where we are. That's the update that I would like to give to you this morning. In terms of conclusion, I think I can say we have an interesting year ahead of us, both on the infrastructure part. We're on the 10T maps, but what will it mean in practice, and how can we ensure that it doesn't stay a paper exercise, I think is an important question. And secondly, how can we find the right form for a good and supportive regulatory framework for the port industry? Thank you.